Yes.
Let's say I'd like to mention 5 batch matters which were listed on the day before yesterday, Milord, for this honorable court. The habeas corpus matters, Milord. Unfortunately, Milord, they've not been listed today. Although the leftover
Only
matters.
because those part hard matters.
Milord, any fixed date, Milord, convenient for this honorable court may be fixed.
You want to make a mention tomorrow?
Tomorrow. Great.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 1, Your Lordship. Better maybe fix that 2 if possible. Division match.
Division match to the middle field is set out.
Yeah.
Item number 1 of which item? Which list?
No, next page.
Next bench, Your Honor.
Okay.
I can.
Mine is the next program.
Nine.
The next page. Okay. Yeah. Very
May please, Your Lordship. My lord, here in this case, although we have explained the delay, but we have filed a separate IA, and IA has been allowed in the meeting. So, this was registered earlier, but this question was raised, delay question was raised, therefore there is an order to file a separate IA, we have filed and that was allowed.
By which order?
My lord.
By which order?
My
I
lord,
was allowed?
in IA, that is IA number 2803, 2022.
There is no order. That's why I'm asking you by which day?
My lord, sorry, my lord, I may be wrong, my lord, but IA has been filed. But there was explanation of delay in the petition itself, in paragraph 32, that after the judgment on the division bench, the petitioner number 2 was arrested and he was in the custody for about 2 years. One is lady, my lord, lady of remote village, and she was traumatized because of the arrest of her husband. So that was the explanation. There was also lockdown situation. That was the explanation in paragraph 32 of the petition.
Your explanation for the delay of 934 days is at para 32, right?
My lord. And we have a separate IA also. IA number 2803, 2022.
Similar grounds you have taken there
My lord.
because you are in custody or in detention for
Yes,
2 years.
my-
Fine. Now please come for the review.
My lord, in the petition,
Why this order needs to be reviewed?
my lord. Here in this case, my lord, the learned tribunal has disbelieved everything only on one point, that the proceeding, the petition number 2 is stated before the police that his father is Abdul Ali. But he claimed during the trial that his father is Abdul Rashid. And tribunal has disbelieved because he made statement before the police that his father is Abdul Ali. Now, my lord, in the proceeding, my lord, in filing the WS also, he raised contention that the case has been referred without fair and distinction. Police never approached him in connection with the citizenship status.
Mr. Secretary Justice.
My lord.
Yes, please proceed.
My lord, kindly have a look at my lord, annexure 4, page 36 of the WS. Paragraph 3 and 4 is relevant. It is the contention of the petitioner that the police raised false allegation against the respondent in para 3, para 4, that without inquiry and without looking into the documents and entire false allegations are raised against the respondent. So his contention is that the police did not make any investigation. That was also similarly he stated before the tribunal during evidence.
Just a minute, please.
My lord.
Yes, Mr. Sikdar, please come to the grounds for which you are filing this.
My lord, my first ground is that when there was no fair investigation, and even my lord, the police was examined, he also accepted, he has also admitted that during investigation, there was no any other person except the police. And what commission also state that none has approached him to make an inquiry about the status of the petitioner. And that being the position, whether the tribunal was correct in accepting the inquiry report as an evidence, as an rebuttal evidence of the petitioner, whereas the petitioner too is himself voter in 1971. So that is my first point, that there is a preliminary my lord, right to raise against the fairness of the investigation. When there is no fairness in the investigation, so my lord, right under Article 21 has been violated. My lord, the Supreme Court in Sarvanda 2 case has said in para 60 that initial owners of the state initial owners of the state is to be discharged. That has not been done. And there was no fair investigation. So the inquiry report, accepting the inquiry report as an rebuttal evidence is the only evidence, ignoring my evidence, my lord. Whereas the petitioner too himself is the voter in 1971. How that can be, my lord? And there is my lord, Evidence Act, section 2526, that has provided clearly that evidence statement made before the police cannot be an evidence. So this is a glaring mistake in the law, my lord. How this inquiry report can be accepted as an evidence, as a rebuttal evidence against my evidence, my lord. That is a glaring mistake, my lord. And to that effect, there is judgment of the Supreme Court, my lord. I am coming to rely on that, my lord.
Just a
I could. No.
Hmm.
120, madam. Yes. Applications for review of judgment. Chapter application for review of judgment. The provision of chapter 4 shall apply so far as may be to every application for review. Every application for review of judgment shall set forth plainly and concisely the grounds on which a review is sought and shall contain a certificate by an advocate of the court similar mutates mutandis to the prescribed in appeal form and appellate decree. When the application for review proceeds on the ground of discovery of fresh evidence, certified copy of the documents, if any, relied upon shall be annexed to the application together with an affidavit setting forth the circumstances under which such discovery had been made. Yes, ma'am. Division bench, division. Yes. Yes, ma'am. Certificate is necessary. Certificate is to be, yeah, ma'am. Certificate is ma'am. Yes. Not in compliance. My lord, my submission is that, my lord, that the chapter 10 is to be complied. But of this Guwahati High Court Rule, chapter 10 has to be complied if it is a review petition, first of all. And that is a ground for, that can be a ground for, my lord, rejection of the not accepting the review, my lord. Secondly, under aspects of there, my lord, there is no ground because আপনি কি in this comment?
Correct করলেও correct মেমোরি আমার এটা কি সার্টিফিকেট নাকি
collect করে পিকেও affidavit হবে under হচ্ছে
এফিডেভিট পে লিখতে আর একটু ভেরিফিকেশন পেটা
Verification.
কিন্তু গ্রাউন্ড মোড হয়ে আই উইল সাপোর্ট দ্যাট
I will not go beyond that.
According to me, it is a mistake which can be corrected. Yes, my lord. Whether it is a mandatory, it is a mandatory provision, mandatory provision.
My lord, my lord, it's a provided mistake, my lord. My lord, I may be allowed to without the liberty to file a case on.
আমার So, we basically hit the Karnataka delayed explain to me. The other thing was I would rule a very
I don't know. If it is a pointer, by
My lord, the liberty may be given.
it is for a new ground cannot be. Because they will like new ground.
Everything, all grounds are same.
Because there will be another.
No.
No, ma'am. Order dated 02/07/2010 of WPC was submitted in detail. Nay. Nay. No.
Oblige.
Lordship, my senior election code number 15, he will come in shortly. Lordship, in this case, Mr. G. Goswami has already argued the case, but today he's before Lanab Central Administrative Tribunal, Lordship. One hearing is going on. Yes, Lordship. He's coming. Yes, Lordship. Lordship. Yes, sir. Yes, sir. That is the rejoinder, Lordship. Yes, Lordship. Yes, Lordship. Yes, yes. Yes. No. Yes. Yes, Lord. Yes. %50. Right. Yes. 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 Yes.
I will point out it regarding the fitness and the charges of unauthorized action. The what the appellant has now projected that his past service was considered while imposing the penalty of removal from service. The order of the disciplinary authority, stated at page 30. What the disciplinary authority has considered at the time of imposing the penalty. Yes, Lord. Sir, regarding the Lordship, first of all, there was violation of the statutory rule, that is Railway Servant Disciplinary Scale Rule, Rule 9. It speaks about the disciplinary procedure for imposing the penalty. This is the Rule 9 of the Railway Servant Disciplinary Scale Rule. It is equivalent to the Rule 14 of the CCA. The Rule 9 sub-rule 6. Lordship, in my written argument I have given. I have given one written argument that I have given. Lordship, this memorandum of charge was issued under Rule 9. I have given one written argument. Lordship, in CCS rule 14. Yes, but this is a statutory rule under yes, Lordship, it's statutory rule, so it's having the force of law. Now, Rule 6 speaks about how to prepare the search. Rule 9, sub-rule 6. I'm reading this rule regarding that. Where it is proposed to hold an inquiry against a railway servant under this rule and Rule 10, the disciplinary authority shall draw up or cause to drawn up the substance of imputation of misconduct and misbehavior into definite and distinct article of charges. The article of charges must be definite and distinct. Secondly, a statement of imputation of misconduct or misbehavior is supported of each article of charges, which shall contain a statement of all relevant facts, including any admission or confession made by the railway servant. B, a list of documents by which and a list of witnesses by whom the article of charges are proposed to be sustained. This is the first. Now, the memorandum of charges, the charges which were framed against me were vague. This memorandum of charges, it starts from page 52 of the report. And the charges are at page 58. Article 1. The statement of article of charges framed against Sri Pradeep Kumar Nandi, technician grade 3 of the T of 1718, Article 1. As per the attendance report submitted by the SSE CRS DBWS, height dated 21/3/2008, Sri Pradeep Kumar Nandi, technician grade 3 T of working under SSE CRS DBWS is most irregular in his duty. He is in habit of remaining absent from duty very frequently. This is a serious misconduct in violation of Rule 3.1, sub-rule Roman 1 and Roman 2 and Roman 3 of the Railway Services Conduct Rule 1966. The statement of imputation of misconduct and misbehavior in support of the article of charges framed against Sri Pradeep Nandi, technician grade 3, that Sri Pradeep Kumar Nandi, while working as the technician grade 3 under SSE of the CRS DBWS is most irregular in his duty. He is in habit of remaining unauthorized absent from duty very frequently, and subsequently he reports for duty, converting the period of unauthorized absence from duty under PMC, that is private medical certificate. Previously, Sri Nandi was taken up under DAR for several times, and for his habit of remaining unauthorized absent from duty, and lenient view was taken to offer him scope for improve. But it has been seen that he has not improved at all. Rather, he is repeating the same offense, remaining unauthorized absent from duty. This persistent habit of remaining unauthorized absent from duty indicates the gross lack of devotion and negligence to duty, which is a serious misconduct on the part of Sri Pradeep Kumar Nandi, showing himself to be unbecoming by railway service. This was the allegation. When there is allegation of unauthorized absence, that period must be definite and that should be clearly stated. And when it is the second article, they are saying that he is in habit of remaining unauthorized absent earlier. That period where the lenient view was taken, those documents must be produced during the inquiry, and this has caused prejudice to him. Now, what they have annexed? The annexed that list that your lordship has pointed out, that page 59. It is the list which shows that he remained absent on full for 19 days and half for 10 days. And that includes 6 days on casual leave. That was also considered to be, once the casual leave is granted, that cannot be an unauthorized. And once he is absent for half day, that cannot be the absentee for the entire day. So that is why the vague charge was framed against him. And on the basis of that, the inquiry proceeded, where he has admitted his guilt. Now, what he has admitted, his admission was that in page 62, he has admitted, he has given the reasons, page 62. There are two things. One is at page 64 and one is at page 62. The page 62 was DAR that was taken up on 4/4/2008, held on 25/9/2008. Here, the second question was put to him, that is at page 62. I am reading from the page 62. Why did you remain absent from duty frequently? My mother is a psychiatric patient in her old age. She is residing with me and I have to look after her. Frequently, she becomes ill. Sometimes she goes out of the house and is missing. As I have to look after her, I have to take care of my mother during her sudden frequent illness and to fetch her while missing. For this reason, I have to remain frequently absent. This clearly shows that though he was absent, that was not will. He was under compelling circumstances, he remained absent. And next is at page 64. Last question. Do you accept the charges against you? I accept the charges. This has happened because he was asked why he was absent for that particular period, and he has given the answer to that. That due to the vagueness of charges, he could not give the specific answer that for this reason I was absent in this period, this reason I was absent in that. Because the second charges he was remain habit of unauthorized absent very frequently and report for duty with TMC, nothing has been produced during the inquiry. Not even before the tribunal, these documents were produced. Now, before your lordship, they have produced a piece of paper stating to be the PP4, PP5, that is an Annexer 8. This paper does not bear any signature seal of the railway authority, and this cannot be placed. Lordship, page 109. Now, by this paper, his service particular has been produced before this honorable court. It's a handwritten paper where there is no seal, nothing. And this was produced for the first time before your lord. Even before the tribunal, this was not produced. So this cannot be taken into account at this stage. Now, lordship, thereafter, the inquiry officer, the findings of the inquiry officer, that is at page 66. Lordship, now how the inquiry report is to be prepared? That is given in the Rule 9, Sub-Rule 25, Sub-Rule 1. Rule 9, Sub-Rule 25, then Roman 1. Now it is Lordship, this Rule 25, it says that after conclusion of the inquiry, a report shall be, this is Rule 9, Sub-Rule 25, Roman 1. After conclusion of the inquiry, a report shall be prepared and it shall contain what it should contain. That is the article of charges and the statement of imputation of misconduct or misbehavior. The defense of the railway servant in respect of each article of charges. An assessment of the evidence in respect of each article of charges. The findings on each article of charges and reasons thereof. Explanation. If in the opinion of the inquiring authority, the proceedings of the inquiry establish the article of charges different from the original article of charges, it may record its findings on such charges. Now, lordship, what is the finding given by the inquiry officer? That is at page 66, the findings column. The CO, Sri Pradeep Kumar Nandi, technician grade 3, has accepted the charges framed against him. It is observed that from the attendance sheet SN20 submitted by the COS of the TO of the DBOS that he is irregular and remain absent. The report of the OS field SN22 reveals that he had not submitted leave application for his absentee period except commuted leave for from 12/3/2008 to 17/3/2008. In the light of the above evidences available as presented in the foregoing paragraph, article of charges against the defendant, Sri Pradeep Kumar Nandi, technician, is established. Now he has neither said about the second article of charges, that is that he was in a habit of remaining absent. What they have considered the report given by the CHOS of the TO of the DBS. That is annexer. That is the report that is at page 60. That is the absentee from the definite period, that is from it starts from page 59, that is from 118 to 21/3/2008. This is the page 59 and 60. On the strength of this report, he has stated that the charges have been established, meaning thereby that what he have considered the absentee period from 118 to 21/3/2008, not the previous any misconduct. Those were not taken into consideration while submitting the inquiry, and he has failed to give any distinct and definite findings to the charges. What he has stated that he is in habit of remaining absent during this particular period. That is the conclusion, and that is also vague. He has not stated for which period he was found absent, and he has given a vague reply. Now, Lordship, then comes to the order of the disciplinary authority. That is at page 67. Lordship, second paragraph, not in the first one. The charges framed against CO is serious misconduct in regard to his habit of remaining unauthorized absent from duty very frequently for the period from 1/18 to 21/3/2008. The disciplinary authority has not considered the previous absentee, what has been projected before your lordship now at the appellate stage. That was not considered by the disciplinary authority while imposing the penalty. What he has considered, the charges framed against the CO is serious misconduct in regard to his habit of remaining unauthorized absent from duty very frequently for the period from 1/18 to 21/3/2008. This is the charge what has been considered. The IO in his findings has clearly indicates that from the inquiry and on examination of the attendance statement and leave particulars, it has been seen that the CO, Sri Pradeep Kumar Nandi, is most irregular in his duty and habitual in remaining unauthorized absent from duty. He himself have accepted the charges in the course of ER inquiry. The IO has found the charges to be proved. Now, what is the charge? That is the charge for remaining absent from 1/18 to 21/3/2008. Now they are saying that they have considered the previous misconduct, if any, and they, for that reason, to support that, they have produced a handwritten note sheet where there is no signature or nothing. Now, what the appellate authority has considered. Now he has preferred an appeal. In his appeal, he has stated that in appeal is at page 68, and it is the appeal preferred by him. He has considered that period, that from 1/18 to 21/3/2008. That was under consideration, and now appellate order is that is at page 7. Now, what the appellate authority findings of the appellate, I have gone through the complete case and observed that charges leveled against the CO is serious misconduct in regard to his habit of remaining unauthorized absent from duty very frequently from the court from period 1/18 to 21/3/2008, and they have been accepted by the CO, the courts of the year inquiry. Now he preferred a revision there. Now the revisional order is at page 74. Now there in para 5, it is stated after careful para 5 of the divisional order, that is at page 74. After a careful consideration of the point made by CO in his division petition, it is noted that he was given full opportunity to defend his case and defend his case. After the issue of the charge sheet, which he used to defend himself, and he even accepted the charges in the inquiry procedure. He gave certain reasons for unauthorized absence, which was considered by the EO and EO and the article of charges were found to be true. Now the explanation was not considered. You have given a vague finding, that is the 1500 inquiry has given a vague finding. The charges are true. He has not said whether it is willful or not, that part was not dealt with by the you. And this finding is not correct. And that is why and during entire disciplinary proceeding, the period of absentee was from 118 to 21/3/2008. That period was considered, that was taken into consideration. He has admitted his guilt for that part, and that contains 6 days scheduled leave, 10 days half day, and 19 days full. That is the total period of 90 days. Yeah. That is the period of absence. And thereafter, he preferred an OA before the Honorable Tribunal. Lordship, that was preferred in the year 2015. And he then, there was a petition for condonation of delay. That was considered and delay was condoned. And that was not no appeal was preferred against that condonation of delay. That was in by the mixed case number 40/400/410. Sorry, Lordship, this is 40/00111199. Lordship, I have given a copy that and originally the copy is there. Copy to Xerox. Lordship, that delay was put, and that has already attained final. That was taken into consideration, the delay was taken into consideration. That is why the 100% packages are not given. Only 50% was awarded. These were everything was taken into consideration by the tribunal. And that delay was controlled, and that they did not prefer anything, so it has attained final. Now at this stage they cannot edit it. Now regarding the vague certificate, yes, Lordship. Lordship, I'm just pointing out certain judgment. So there was a statutory rule for doing this inquiry, and they will have to do this on by following that rule. Before, first of all, they will have to issue the certificate distinct and definite. That was not done. So there is a judgment. Anil Gulikar versus Bilaspur Raipur Kshatriya Gamin Vikas Time. This is reported in 2011 14 SCC 379. Lordship, Para 10. The position of law has been reiterated in the recent judgment of Union of India versus Gyan Chandra Sattar, Para 35 of the judgment reported in the SCC. This court has observed that the law can be summarized that an inquiry to be conducted against any person giving strict adherence to the statutory provisions and principles of natural justice, and charges should be specific, definite, and giving details of the incident which form the basis of charges, and no inquiry can be sustained on the vague side. But then I'm relying on the Surat Chandra Chakraborty versus State of West Bengal. It was reported in 1973 SCC 548. But here in the case 5, the first para, middle portion. Wrong para. It is para 4. para 4 and page 5. In page 5. That we, I'm reading from the first portion of the case code. First middle code. Tenth line. The fundamental provides entirely that without prejudice to the provisions of the Public Servant Enquiry Act 1850, no order of dismissal, removal, or reduction shall be passed on a member of the service unless he has been informed in writing of the ground on which it is proposed to take action. He has been afforded of adequate opportunity to defend himself. The ground on which it is proposed to take action have to be reduced to the form of definite charges or charges which have to be communicated to the person charged together with a statement of all allegations on which the charges is based and any other circumstances which it is proposed to be taken into consideration in passing the order has also to be stated. The rule embodies that a principle which is one of the basic contents of the reasonable or adequate opportunity for defending oneself. If the person is not told clearly and definitely what is the allegation or what the allegations are on which the charges preferred against him are founded, he cannot be possibly, by projecting his own imagination, discover all the facts and circumstances that may be in completion of the authorities and to establish the against him. By way of illustration, one of the grievances of the evidence contained in the letter substance is regarding that particular person. Now coming to the down below, that is the second last para, third line. As stated before, the charges should be accompanied by the statement of allegations. The whole object of furnishing the statement of allegation is to give all the necessary particulars and details which could be satisfy the requirement of giving reasonable opportunity to put the defense. The evidence repeatedly and at every stage brought it to the notice of the authorities comment from the that he has not been supplied with the statement of allegations and that charges were extremely vague and indefinite. So that is why it was considered and appeal was allowed. Yes, sir. But regarding the previous misconduct, that was not provided. So there is a judgment. It is settled principle of natural justice that if any material is thought to be used in inquiry, then the copies of the material should be supplied to the party against whom such inquiry is held. That is Government of Andhra Pradesh versus Venkata Raidu, reported in 2007, 1 SCC 388. This is para 9. Here, para 9 says, we respectfully agree with the view taken by the High Court. It is settled principles of natural justice that if a material is thought to be used in an inquiry, then the copies of the material should be supplied to the party against whom the such inquiry is held. Here, Lordship, what has been produced before your Lordship at page 9, that is side noting, that is at 108, page 108, Annex 8, was produced for the first time here only, not before that. So that can be taken into consideration. Now, in Tusharkan P. Parmar versus Union of India, reported in 2012, pre-SCC 178, that was taken into consideration by the control tribunal also. It was held that the departmental proceeding, if the allegation of unauthorized absence is made, the disciplinary is required to prove the absence is willful. In absence of such findings, the absence will not amount to misconduct. Now, to be a misconduct, it must be the inquiry officer must give a reason, give a finding that this his absence was not under compelling circumstances, but will. That was not there. He has given a vague finding that charges are due. Now here I am relying on para 19. In a disciplinary proceeding, if allegation of unauthorized absence from duty is made, the disciplinary is required to prove the absence is willful. In absence of such findings, the absence will not amount to misconduct. Para 19. Now, once this penalty is set aside, then he is entitled to take with. That is Indian Railway Establishment Code is there. Lordship 1344. It is equivalent to FR 54A. This is also a statutory code under Article 309 of the Constitution of India. This is Indian Railway Establishment Code, where the dismissal, I am reading Rule 1344. It is in page number 15. Oh, sorry, 11 of the code. Where the dismissal, removal, or compulsory retirement of a railway servant is set aside by the court of law, and such government servant is reinstated without holding any further inquiry, the period of absence from duty shall be regularized, and the government servant shall be paid all allowances in accordance with the provisions of Sub-Rule 2(3) of subject to the direction, if any, of the code. So, as per this rule, he is entitled to the entire benefit, but as per the direction of the Honorable Tribunal, he is only entitled to 50%. So, 50%, he will have to stick to the 50%. And chairman come managing director, Coal India Limited, and another versus Kumar Chaudhary and others, reported in 2009 15 SCG 620, para 20. I'm reading that from 9th and 10th line. Yes, Lord, this was also considered. Then Umesh Kumar Jha. Then Umesh Kumar, Lordship, in Mukul Kumar Chaudhary, I am relying on para 26. Here, Lordship, from the 10th line, in a case like the present one, where the misconduct of the delinquent was unauthorized absence from duty for 6 months, but upon being charged of such misconduct, he fairly admitted his guilt and explained the reason for his absence by stating that he did not have any intention or nor desire to disobey the order of the higher authority or violate any of the company's rule and regulation, but reason was purely personal and beyond his control. And as a matter of fact, he sent his resignation, which was not accepted. The order of removal cannot be held to be justified. Since in our judgment, no reasonable employer would have imposed extreme punishment of removal in like circumstances, the punishment is not only unduly harsh but also grossly excess to the allegation. Ordinarily, we would have said that he was not sent back. So, Lordship, this is Mukul Kumar Chaudhary, Coal India Limited, Chairman come Managing Director Coal India Limited, and another versus Mukul Kumar Chaudhary. This is para 26, last para 26. Here from 10th line from the of the para 26. Exclude irrelevant matters before the imposing punishment. In case like this, here. So that here also he has admitted and he has explained what under what circumstances he was compelled to remain absent. So his due to his mother's sickness. And here the absentee was for 6 months, and in my case it is only for 19 days in full and 10 days in half, and there are 6 CLs. Then another judgment of this honorable court, the way this is reported in 1998 to GLT 315 para 7 315. It is Ilongbang Nimai Singh versus State of Manipur. Here I am relying on para 7. Para 7, fourth line from top. This is following thesis of property dictatorship. So here also backwise is also in this para 7 and 8. In 8 the backwise is directed. In 10 I am relying on the judgment of Cargo Motors Gujarat Limited versus Shivaji Rao Jadab. That is application number 10898 of 2018. Here I am relying on last 4 lines of the para 5. Proceed here in Cargo Motors last 4 lines of para 5. It is settled law that in case of termination of employment, though award of back wage is not automatic with the award of reinstatement, but in a case where fault is found on the part of the employer, 100% back wages can be provided. The fundamental principle is that no one can take benefit of its own law. So he is entitled to have 100%. And because he has approached the tribunal at a related stage, so he has given sufficient explanation for that. So 50% was awarded. So he has not said anything. Here, termination was turned out during the tribunal found fault on the part of the respondent in terminating his service by imposing the penalty of removal from service for small period of absence. That too not willful absence. So that is why that was considered and termination was found to be illegal, and that is why he was reinstated and 50% back was awarded. Then there is another judgment, there is appeal number 6188 of 2019. That is para 38.5. It is case C. The cases in which the competent court or tribunal finds that the employer has acted in gross violation of the statutory provision and or the principles of natural justice, or is guilty of victimizing the employee or workman, then court or tribunal concerned will be fully justified in directing payment of full back wages. In such cases, the superior court should not exercise power under Article 286 or 136 of the Constitution of India, Constitution, and interfere with the award passed by the labor court. So here the tribunal has found that there was violation of the statutory rule, and Rule 9 was violated. Thereafter, there is disproportionality in the penalty imposed. So that is why the 50% of back wages was awarded. These are the I have given the gist of all these judgments in my written. Like, that all along from the disciplinary authority, appellate authority, or the inquiry report, all along, they considered that my absentee was within the period of from 1/1/2008 to 21/3/2008. Now in the appeal, for the first time, what they are saying that by imposing the penalty, they consider the past service, previous conduct, and previous misconduct. And for in support of that, an Annexure 8 was placed before you. And this was not their case. All along they have considered only in between, and the penalty which was imposed was highly disproportionate. That is why the tribunal has struck it down for such absentee, and they are saying that the entire period I was absent, but their own report says that I was not absent for entire period. 6 days TL, 10 days half day I was present, because this is an workshop. It works on shift. I was an employee of the radio workshop, not the open line.
Malat, I am extremely sorry. I was in an equipment. Malat, I'd like to place Malat two judgments, Malat, if you also can allow me. Malat. Hmm, 2022 18 SCR 605. 18 SCR 605. Malat, in this case, Malat, there are two charges, Malat, mainly, Malat. Number one, Malat, he is an habitual offender. Previously, also, Malat, he was taken by BAR, and Malat, a lenient attitude was Malat shown, Malat, to Malat improve, Malat. And Malat, punishment also was inflicted, Malat, which he has admitted, Malat, that he was taken by Malat disciplinary committee, Malat. Malat, now the second charge, Malat, he has, since he has continued, Malat, Lordship has gone through all these Malat days, Malat, Malat, how many days he was absent, Malat. But my lord, this is not the first instance. And my lord, on the basis of this instance only, my lord, the punishment was not inflicted, my lord. And secondly, my lord, as my lord, my learned friend has already pointed out that my lord, there is a delay, my lord, and delay was my lord condoned, my lord. Lordship, my lord, Lordship, I have seen the judgment, my lord, order, my lord. How, my lord, the delay was condoned? Though, my lord, it was not, my lord, opposed, my lord. My lord, it was though opposed, my lord, and my lord, we prayed for my lord filing and my lord objection, my lord. It was, my lord, not allowed, my lord. And my lord, under that, my lord, situation, my lord, the delay was condoned, my lord. And my lord, I have taken that ground also, my lord, in this in the writ petition, my lord. Both the grounds, my lord, delay as well as my lord, the punishment, my lord, given to the petitioner is not disproportionate, my lord. Now, my lord, coming to this judgment, my lord, my lord, para 8, my lord, from para 8, my lord. My lord, similarly, my lord, here also, my lord, the search officer, my lord, has preferred, my lord, appeal revision, my lord, etc., my lord. Para 8, my lord, may I read, my lord? Dissatisfied by order passed by the revisional authority upholding the order of disciplinary authority, the appellant authority, the respondent filed writ petition in the High Court of Calcutta, registered as so and so. The said petition was disposed of by the learned single judge, filed order dated 25th June 2018, and punishment of dismissal imposed on the respondent was converted to the compulsory retirement, primarily on the ground that authorities has failed to preserve the relevant record. Now, the second part is not so important. Come to the next para, para 9, my lord. The aforesaid order was challenged by the appellant Union of India in 2 sets of appeal that were disposed of by the division bench filed Indian judgment dated 9 September 2021, whereby the decision of the learned single judge of substituting the punishment of dismissal imposed on respondent with one of the compulsory retirement was quashed and set aside. Instead, it was directed that the respondent could be entitled to be reinstated in service along with full back wages from the date of his dismissal. The disciplinary authority was further directed to issue a fresh order of punishment in respect of the respondent that should commensurate with his negligence and dereliction of duty, other than a punishment of dismissal, removal on service, or compulsory retirement. More or less similar to my now coming to para 11, some judgment were cited, para 11, BC Saturday versus Union of India, that the High Court, while exercising the power vested in it under the judicial review, ought not to have stepped into the shoes of appellate authority and reappreciate the evidence to arrive at independent finding of the evidence adduced that no grievance was raised by the respondent, that the rules of natural justice has been violated, or the inquiry had not been conducted in a proper manner, or that the finding arrived at by the disciplinary authority were based on no evidence. Now, next para, para 12, citing the decision of state of Orissa and others versus Vidyabhushan Mahapatra, it was contended that keeping in mind the gravity of established misconduct, the disciplinary authority has the power to impose a punishment on the delinquent officer, and such a punishment is not open to review by High Court under Article 226. It was also sought to be urged that the appellant, that the past conduct of the respondent can be taken into consideration while awarding penalty, subject to condition that the same is made a part of the separate charge. Here, my lord, exactly, my lord, it was made a part of separate charge, my lord. And my lord, my learned friend has questioned how, my lord, it was proved, my lord. My lord, it not requirement of proving that fact, my lord, because he has, my lord, admitted his guilt, my lord. And my lord, another argument was made, my lord, on behalf of the respondent, that he has not understood, my lord. If he has, my lord, kindly see, my lord, the WS filed by the respondent, my lord, before the my lord, Central Learned Tribunal, my lord, where he had admitted that yes, I was taken by DAR. So, my lord, not understanding this charge, my lord, the question of not understanding this charge does not arise, my lord. Now, my lord, para 14. Para 13, the para 14, the point that arises for our consideration is whether in the given facts of the case, the learned single judge and the division bench ought to have interfered with the punishment imposed on respondent by disciplinary authority and upheld by the appellate authority, as also by the revisional authority. Para 15, my lord, it is well settled that court ought to refrain from interfering with the finding of fact recorded in the departmental inquiry, except in circumstances where such findings are patently perverse or grossly incompatible with the evidence on record, based on no evidence. However, if principles of necessary justice has been violated or statutory regulation had not been adhered, there are malafide attributable to the disciplinary authority, then the court can certainly interfere, my lord. Para 16, my lord. Another judgment was quoted, my lord. Judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Part of judicial review is meant to ensure that the individual receives fair treatment and not ensure that the conclusion which the authorities reaches is necessarily correct in the eye of court. When an inquiry is conducted on charge of misconduct by the public servant, the court tribunal is concerned to determine whether the inquiry was held by the competent officer or whether rules of necessary justice are completed. Now, my lord, the bold portion, my lord, I'll read, my lord, the bold portion, my lord. The court oblique tribunal is in its power of judicial review, does not act as an appellate authority to reappreciate the evidence and to arrive at its own independent finding on the evidence. The court tribunal may interfere where the authority held the proceeding against the delinquent officer in a manner inconsistent with rule of necessary justice or in violation of statutory rules prescribing the mode of inquiry, or where the conclusion of finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding of such reasonable person would have ever reached, the court tribunal may interfere with the conclusion of the finding and mold the relief so as to make it appropriate to the fact of its case. 13, the disciplinary authority is the sole judge of the fact where appeal is presented. The appellate authority has coextensive power to reappreciate the evidence or the nature of punishment. In a disciplinary inquiry, the strict proof of legal evidence and finding on that evidence are not relevant. Adequacy of evidence or reliability of evidence cannot be permitted to be canvassed before the court oblique tribunal. Now, my lord, next para, my lord, para 18, my lord. A review of the above legal position would establish that the disciplinary authority and on appeal, the appellate authority, being fact-finding authority, have exclusive power to consider the evidence with a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view the magnitude of gravity of misconduct. The High Court tribunal, while exercising the power of judicial review, cannot normally substitute its own conclusion on penalty and impose some other penalty. If the punishment imposed by the disciplinary authority or appellate authority shocks the conscience of the High Court, it is appropriately mold the relief, either directing the disciplinary authority to reconsider the penalty imposed or to shorten the litigation. It may itself, in exceptional and rare cases, impose appropriate punishment with cogent reason in support of thereof. Para 17, the bold portion. It is now well settled that the court will not act as an appellate court and reassess the evidence laid in the domestic inquiry, nor interfere on the ground that another view is possible on material on record. If the inquiry has been fairly and properly held, the findings are based on evidence. The question of adequacy of evidence or the reliable nature of evidence will not be ground for interfering with the finding in the departmental inquiries. Now, my lordship may kindly come to para 26, my lord. I'm speaking some portion, my lord. Para 26, my lord. 622. my lord, I'm reading, my lord. We have noted above that finding of the disciplinary had made with the approval of appellate authority and the revisional authority. However, the learned single judge overturned the order of dismissal from service and converted the same to compulsory retirement on the sole ground of non-availability of original record. More specifically, the bid book, while giving go by to the extract of the bid book that was produced before the inquiry officer and the respondent had admitted the said document. The last line out of the para, departmental inquiry was vitiated on account of violation of natural justice or that the inquiry had been conducted in gross violation of statutory. This is the only ground, my lord, where, my lord, the order can be set aside, my lord. The division bench went a step further. Next para, my lord, and proceeded to reappreciate the evidence and observe that it was not persuaded to conclude that such major theft of 800 kgs comprising of 42 bundles of copper wires could have been happened in the blink of an eyelid, despite holding, my lord. Para 28, my lord. Now, para 28, my lord. We are unable to comment the approach of the learned single judge and the division. There was no good reason for High Court to have entered the domain of the factual aspect relating to evidence recorded by the inquiry. This was clearly an attempt to reappreciate the evidence, which is impermissible in exercise of power of judicial review vested in the High Court under 226 of the Constitution of India. This is the, my lord, and my lord, it is now, my lord, this is one, my lord. Now the second, my lord, this is more important, my lord. I'll place, my lord, 2014 4 SCC 108. My lord, I'll start from para 4, my lord. Para 4, my lord. My lord, before that, my lord, the previous line, my lord, yet he chooses not to submit his explanation till 6/1/1997, much after the search sheet was issued, my lord. In my case also, my lord, he was asked to submit his written my lord, statement, my lord. He never, my lord, submitted his written statement. In fact, my lord, he admitted his written, my lord. Now, my lord, the para 4. As the factual matrix would further uncertain, an inquiry was conducted against the respondent, and his explanation in the inquiry was that he could not attend to the duties and could not give an explanation to the first search memo because of ill health, my lord. Same case, my lord. His mother's illness, my lord. The inquiry officer found charges were proved and accordingly submitted the inquiry report, which was accepted by the disciplinary authority. And after following the due procedure, punishment of dismissal was passed on 1998. In the order of dismissal, the disciplinary authority observed that belated submission of medical certificate. Here also, my lord, medical certificate was belatedly, submitted. Sorry, the medical certificate on 1/4/1997 irresistibly led to the conclusion that the respondent employee was unauthorizedly absent from 28/8/1995. Para 5, I'm skipping some lines. On the appeal being preferred by the respondent, the board rejected the appeal on 30/6/1998, being dissatisfied by the order of dismissal and the affirmation thereof in appeal. The respondent preferred the W. So and so. The learned single judge by order dated so and so directed reconsideration of the appeal solely on the ground that managing director, who was the disciplinary authority, has taken part in the proceeding of the board which decided the appeal. Now, para 6, my lord. The grievance of reaffirming of the order of dismissal was agitated by respondent in WPC number so and so, which was preferred on 7/7/2007. The appellant board in the counter affidavit defending the order of dismissal stated that only reason given by the employee was that he could not attend the duties as was availing continuous treatment for tuberculosis. And further, he also met with an accident in September 1995, which was unacceptable. In addition, it was stated in the counter affidavit that bunch of medical certificate was produced by him on 1/4/1997, which mentioned that he was suffering from depressive psychosis and bronchitis and there was no mention about any accident and injury sustained by him in September 1995 and treatment available by him. The learned singers by the impugned judgment, after narrating the facts, noted that the statement of the learned counsel for the respondent that even if the employee had absent from the duty, there was no past misconduct or desertion absence, and therefore the punishment of dismissal from the service for the first time, the desertion absenteeism is too harsh and disproportionate. These are to be interfered with. The learned singers did not adhere to any other fact. Some judgments were quoted, my lord. Next para. Applying the said judgment to the fact of this case and considering the counter filed by the respondent wherein it is stated as to whether the petitioner has deserted, absented on any previous occasion, this court is of the view that the writ petition deserves to be allowed. This writ petition is allowed with direction to respondent to reinstate the petitioner with continuity of service but without back wages within a period of 4 weeks from the date of receipt of the copy of this order, my lord. Similar to this, my case, my lord. Para 8. Grieved by the aforesaid order, CMWSSB preferred read appeal number so and division bench accepted the conclusion of the learned single judge by stating thus. My lord, stating that it is not in dispute that the respondent writ petitioner was unwell during the said period, though there might have been some discrepancies in the date of certificate issued. My lord, lordship may kindly come to the last line of this para, my lord. Further, the learned single judge, while setting aside the order of dismissal from service, rightly denied the back wages to the respondent writ petitioner, as the respondent writ petitioner failed to discharge duty during the relevant period, my lord. My lord, this is my concern, my lord. He was, my lord, his reinstatement was not stayed. So he was reinstated, my lord. My submission is that, my lord, he never, my lord, file any appeal, my lord, by coming to the tribunal, my lord. Now, my lord, he is not entitled to any back wages, my lord. That is my specific submission, my lord. Now, my lord, coming to para 12, my lord. Para 12, it is not in dispute that the inquiry officer found both the charges have been proved. The disciplinary authority had ascribed reason and passed an order of dismissal from service. On a perusal of the order of dismissal, it is vivid that medical certificate was belatedly submitted. My lord, here similar case, my lord. And he had remained unauthorized absence from 28/8/1995. The question that arises when the charge of unauthorized absence from a long period had been proved, was it justified on the part of the High Court to take resort to the doctrine of proportionality and direct reinstatement in service? Thereupon, one aspect which has not at all been addressed by the High Court is that the respondent invoked extraordinary jurisdiction of the High Court after 4 years. This is the, my lord, this is the delay portion, my lord. First, we shall deal with the fact of delay. In Maharashtra SRTC versus Balawan regular motor service, the court referred to the principle that has been stated by Sir Brent Peacock in Lindsay Petroleum Company versus Hurd, which is as follows. Now, the doctrine of laches in court of equity is not an arbitrary or technical doctrine where it would be practically unjust to give a remedy, either because the party has by his conduct done that which might fairly be regarded as equivalent to waiver of it, or where by his conduct and neglect he has thought perverse not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterward to be asserted in either of these cases of lapse of time and delay are most material. My lord, now thing is this, my lord, since my lord, he has not preferred any appeal, my lord, before the my lord, file any application before the tribunal, my lord. 5 years has passed, my lord. Now, my lord, my lord, huge financial burden on the my lord, on over the railways, my lord, to give him back wages. Apart from that, my lord, reinstatement in service with back wages, my lord. Of course, my lord, 50% back wages is given, my lord. Now, my lord, in para 15, my lord, in the state of MP Bhaset Nandalal Jaiswal, the court observed that it is well settled that the power of High Court to issue an appropriate writ under Article 226 of the Constitution is discretionary, and the High Court in exercise of its discretion does not ordinarily assist the trady and indolent or acquiescent and lethargic. It has in further stated therein that if there is inordinate delay on the part of the petitioner in filing writ petition, and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in exercise of the writ jurisdiction. Now, my lord, coming to para 16, my lord, next page, my lord. Doctrine of delay and laches. Thus, the doctrine of delay and laches should not lightly burst aside. A writ court is required to weigh the explanation of part and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the right of the citizen, but simultaneously it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approach the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at a belated stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay only invite disaster for the litigant who knock the door of the court. Delay reflects inactivity and inaction on the part of the litigant. A litigant who has forgotten the basic norms, namely procrastination, is greatest thief of time. And second, law does not permit one to sleep and rise like a phoenix. Delay does bring hazard and cause injury to the lease. So, my lord, in next para also, my lord, this delay laches has been taken care of. My lord, but my lord, the delay has been condemned in our cases, my lord, and my lord, we have not filed any, my lord, any appeal against that order, my lord. Now, my lord, para 19, my lord, para 19, my lord. My lord. My lord. My lord. My lord. No. Yes, my lord. 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 He'll lose his pension and pension, Malad. Now, the pension, Malad, monthly pension, which he is, Malad. But because dismissal of service, in case of dismissal service, Malad, this Malad, he will not be, probably, Malad, to my understanding, Malad, probably he may not be under, but Malad, I am not arguing on that point also, Malad. Malab, my main focus is on the tax. My main focus is on tax wages. Malab, he has retired. Malab, we have Malab produced this order. Yes, Malab. So Malab, he has Malab admittedly he has come before the tribunal after 5 years, Malab. And for 5 years he has not worked, Malab. So Malab, since he has only because the delay was found out, that does not mean that he is entitled to the tax wages. Delay is condemned for the issue of Malab, considering his case continues. But whether he is entitled for the tax wages or not will depend on the merit of the case. And Malab, as per the merit of the case, Malab is not entitled. Malab, I can face another judgment, Malab, where Malab, Honorable Supreme Court has said, Malab, no work, no payment. This is the judgment, Malab. Last, last line, Malab, last page, Malab, last page, Malab. Last page, Malab. Last 4-5 lines, Malab. Top of para 14, Malab. The respondent have not actually worked in the said post, and therefore on principle of no work, no pay, they will not be entitled to in the higher salary. Hence, we give no direction in this behalf and leave it to the appellant to give such relief as they may deem fit, Malab. He was supposed to be promoted, Malab. He was not promoted in time, Malab. And after promotion was given, Malab, he is asking for back wages from the date of Virendra Kumar, General Manager, Northern Railway, New Delhi versus Avinash Chandra Saddha. And Malab, I have not, Malab, I have not been the judgment of Malab of this honorable court, Malab. Malab. So my humble submission is that, Malab, we have not made any delay, Malab, in filing this, Malab, with petition, Malab. Yes, Malab. Of course, Malab, it was filed long back, Malab, in 2018, Malab. Now, Malab, we are in 2024, and that's how Malab, he retired, Malab. That's a Malab separate issue. Lots of people decide that, Malab. But this part, Malab, regarding the back wages, Malab, I am Malab, Malab submitting before the humbly submitting before the honorable court that Malab he is not entitled for Malab back wages, Malab. Due to the Malab delay in coming to the court, Malab. And Malab, immediately on the date of reinstatement, Malab, the date is given, Malab. He is getting, Malab, his salary from the, malab, when malab, we came from, no, malab, from the order of the, malab, when malab, we came here for, on an, malab, filing this writ appeal, malab, there is an order, malab, by the court, malab. So, malab, we have told, malab, to take a decision. Malab, we have taken the decision, malab, that letter was also there, subject to, malab, we have reinstated, subject to the final outcome of this writ petition, malab. We have reinstated them, malab. That order is also with me, malab. Malab, this is the order, malab, malab. Malab, I have only- malab. On the direction of this honorable court, malab, we have reinstated, malab. So, malab, from this date, malab, he was reinstated, malab. And from this date, malab, he is getting his regular salary. So, malab, my humble submission is that, malab, before this date, malab, he was not getting his salary. And, malab, back wages, 50% of back wages of that period, malab. Malab, I am, malab, humbly submitting before this honorable court that, malab, this order of the tribunal may be set aside on the fact and circumstances of this case.
The first is regarding ethics. Now the questions that were put to me does not include a single question where my past regarding the past service and past year. Now what was the question put? On 25th, on the first day, that it was conducted on 17/7/2008. Here the what is your name? The state the designation. Where you are working at present. How long you are working as TRS KBW? Where was your working place before posting at TRS? Have you understood the charges against you? Do you then do you accept the charges against you? That is it. Then now lodged on 25/9/2008. What was the charge? Why did you remain absent from duty frequently? There was no question as to why as regard to his past service or nothing. Now, here, so there was no question, and I have admitted my that period of absence that was inconsidered. Now, coming to the disciplinary authority order, it is clear that they have considered only the period of unauthorized absence from I have shown it earlier. So I am not repeating it again. Now, appellate authority considered that is the 1/1/2008. There was no whisper in the order of the disciplinary authority regarding the past services, past year. Those were not placed before the disciplinary authority. Now, for the first time in the appellate, now regarding the second question of this condonation of delay. The delay was in the judgment that was relied upon. The delay was condoned at the time of hearing. Here, the delay was condoned much earlier. That was not condoned. And that was not so appeal. Here I have explained, and that is why delay was condoned. Now, regarding the appreciation and re-appreciation of appreciation, well settled that the re-appreciation of the evidence is not permissible within the party of each case. But when their punishment is disproportionate and it is shockingly disproportionate, definitely the report can enter. I approached the tribunal. My case was not that the evidence should have been taken in the what was my case? That the rule 9 of the statutory rule 9 of the previous authority rule was not, and appeal rule was not followed. And my absence period was 10 days in full. That time I had said 90 days, it was wrongly I had stated. The 10 days into 90 days in half, and in this is a very short period, and for that period, such a penalty cannot be implemented. It is shockingly disputed. That was my argument before the tribunal, and that was taken into consideration. And why it is only 10 days and 90 days, that I have shown from the disciplinary authorities order. There is no hope, but that past service was never considered by neither by the disciplinary authority, nor by the appellate authority, nor by the inquiry. Nobody has considered it. It is for the first time in this appeal, that is an appeal from the order of the appeal. It is an appeal forum for the tribunal. They have first time come with a notice, and they are saying that this was considered, and that is why the penalty was. Now, what has been submitted is not. It is contrary to the order of the disciplinary authority where it is reflected. We have to go by the order. The order, there was no whisper about the past service that was which was considered, and the DAR was considered, that was considered. That is why this penalty was issued. That is why the tribunal found the penalty to be disproportionate for such a long period of time, and this was once the penalty was found to be illegal, that breakage is there. No more, no way. That is, and because there was that is why 50% was not 100%. Because 100%, their rule says that it is 100%. It's the rule of the railway. I have shown the rule. Now, what has been submitted is contrary to that was not submitted. These are the arguments given before. And regarding delay, now there is no prayer to control the delay, and there is no defense that delay was we were not allowed to file application before condoning the delay. That was not the prayer here. Now, for the first time, these were raised. And this cannot be, because in a recent appellate order forum, what has not been done in the inquiry, that cannot be raised in this appellate forum. We are going to replace it evidence. I am not trying to. My case is not that this is not real. That is my approach.
May I please your lordship? My lord, in this case, almost all the citations the other day I have submitted in the case of Joyfulness are also applicable in this case. Now, Joyfulness review petition number 114/2022. So almost all the citations of that case is also applicable in the present review petition. Review petition number 114/2022. But in addition to this, No, my lord, all the citations almost are applicable in the present case. But this case is better than that case in a sense because my sister has been declared as Indian citizen. Lordship may kindly see page 93. It is Kafia Begum. Kafia Begum is my own sister. And there was a foreigner's proceeding against her. And she was declared not to be a foreigner. For instance, Lordship may kindly see page 94. 2 pages I have typed because the first page of the tribunal's order is not so visible. So here Lordship will see 94, third para. The opposite party, Kafia Begum, wife of Abdul Rahman, resident of village Kharija Paikan, it is her husband's address. Receiving notice from the tribunal, appeared, engaged advocate and filed written statement along with some document claiming that her parents is an Indian and she is also Indian by birth. She was born and brought up in the village Kabaitari, part 4, under Jogikuwa PS in 1964. Her parents' name is Kafur Rahman and Shahar Bhanu. Her parents' name enlisted in the voter list of 1966, 1970, 79, and name of his mother was enlisted in the voter list of 89, 97, etc. Now, Lordship may kindly see the present review petitioners, read petition, kindly see page 28. So, no, let me, again, that page 98 now may be seen, page 98. This Kafia Begum's order is that she is not a foreigner, page 98. Page 98. Therefore, from the facts discussed above, I give my opinion opposite Kafia Begum, wife of Abdul Rahman, resident of village Kharija Paikan, PS, Dudhnoi district, Gwalpara, Assam. The proceedee, opposite party, is not a foreigner of any stream and she is an Indian national. So my own sister has been declared as Indian citizen. Now, kindly see her father and my address. Lordship would see page 26, my lord. Page 26, para 8, Lordship would see that after going through the above evidence on record, it is found that the respondent has claimed herself as bona fide citizen of India by birth, and her parents are Indian citizens who were residing at Kabaitari, part 4 village. Name of her parents were enrolled in the voter list of 1966 from village Kabaitari, part 4. Their name also enrolled in the voter list of 1979. Exactly, her case is also like that. 66, if your lordship desire, then her documents may be again verified, because in page 94 she has clearly stated her Kafia Begum, her parents' name is Kafur Rahman or parents' name enrolled in the voter list of 1966, 70, 79, etc. etc. So this Momena Begum and Kafia Begum are own sisters. And the documents relied by Kafia Begum and Momena Begum are more or less same, excepting few because husband's name is different. After getting married, she used to write her address, the husband's address. Otherwise, so far regarding parents' materials are concerned, they are the same. Now, Lordship may kindly see the case of Abdul Quddus, 2019, 6 SCC 604. Abdul 2019, 6 SCC 604. Para 28. Lordship has seen. May I read, madam? One para. It was highlighted that there could be contradicting decisions, opinions of the Foreigners Tribunal even in cases of near family members. Albeit contradictions can be avoided when family tree hearings are held as is now being undertaken. In the absence of joint decision, conflict is possible as the principle of res judicata would not apply to separate proceedings, even if against two closely related but different persons, as each case has to be strictly decided on the facts and evidence on record. Secondly, there is possibility that one of the near family members may have migrated to India prior to midnight of 24/3/1977, and therefore I think it should be 71. However, maybe typical mistake, and therefore fall in different category. Any such conflict, however, would not compel us to take a different view in terms of the clear statutory provisions. In a given case, the person aggrieved would have liberty to invoke jurisdiction or, if necessary, review jurisdiction before the High Court or this court to ensure that no injustice is done. Any order passed in case of a close family members subsequent to adjudication order determining the citizenship status of a person would necessarily be a material evidence which can be duly taken note and considered while deciding a writ petition or review application. So it is very much clear well. Then any decision near the close relatives. So my close relative is my sister, and she has been declared as foreigner after adjudication. So Honorable Supreme Court says clearly that any adjudication order determining the citizenship of a person would necessarily be material evidence. So this is a better ground than joyful nessa. And overall above joyful nessa was avoiding because when she came to know about that I am against my name there is no D voter, she avoided on that good belief. But here she did not avoid, she appeared and adduced her evidence. So, and her own sister was declared as Indian, which I have just now shown my. Now, if my learned friend says that no, Kafia is not the sister of Momena Begum, then my learned friend has record, he may send it to the SP concerned for to verification whether Kafia and Momena are same sister or not. But they will perhaps not do this, because if that is done, they would be not getting good result. But I invite my learned friend that kindly see that Kafia Begum and Momena Begum are sisters, own sisters or not. If yes, I have a better case. If no, I have no case at all. Now here one thing is, my lord, I have seen the Momena Begum only adduced one witness. Then I asked her, why you have done this? Her answer was like this, my lord, which I have mentioned here in the writ petition. Why you have not not mentioned this? Then she was saying one thing, whether it is lordship would believe or not, that is up to your lordship. But what I have been told, I am telling this, kindly see page 35 of my review petition. There are 26. That the petitioner had named one of her sister as witness in the proceeding, but the petitioner was not allowed to examine her by saying that it was not required, as the case would be decided on the basis of documents produced which has prejudiced the petitioner. So she said that I was told that that is not necessary because everything would be decided on the basis of documentary evidence. So your documents are okay, that is 1966, 70 voter list, etc. So it is, my lord, lordship is that is the settled position of law sometimes, not in a casual manner. Then a new plea may be raised in writ petition, not only writ petition, in review petition also, in writ appeal also. In my Lord Justice Vijay Kumar has the ruling, division bench ruling, our High Court. The new plea may be raised in the writ petition as well as writ appeal. So, in the writ petition, first we have stated that I wanted to adduce the evidence of my sister. The sister's name is not there, but that is another thing. But she wanted, but she was told that your petition will be considered on the basis of document. And document was 66, 70, etc., etc. So, my lord, if these types of documents are disbelieved, then perhaps nobody would be able to prove his citizenship, his or her citizenship. So, in that view, lordship, I have a better case. And thirdly, my lord, in NRC, which was also applicable in the case of Joyful Nessa, my sister's names, etc., have been recorded in the NRC. That I have annexed those NRC, that lordship may kindly see page 85. Page 85, that is the Manurul Haq, who is my brother, Kafur Rahman. Kafur Sheikh, Kafur Rahman. So, Kafur Rahman is my father, and Manurul's father, same person. And Lordship would say Kabaitari, here part 5 is written, there part 4 is written. Sometimes areas are redemarcated. Earlier in the Gao Panchayat areas, my lord, there were no words. But nowadays we see ward number so and so in Gao Panchayat. Earlier we had this in town or cities, but now in Gao Panchayat there will also words are written. So these are the new trend of society, and we should accept this. Similarly, my lord, may kindly see page 87. This is Mohibul Hussain, Kafur Ali, here Kafur Ali, Kabaitari part 5. Then Lordship would see here, the ARN number is also given. Then, my Lord, Mohiruddin Islam, page 89. Here, this Mohiruddin is my son. And father's name is Tajmal Hussain, who is my husband, and Momina Begum is their mother's name, Momina Begum. So, these are the things, my Lord. Similarly, Lordship would see page 91. Here, Kafia Bewa. That Kafia, who has been declared as India's citizen, her name is also there with my father Kafur. Page 91. But it is Krishna town because I was married, that's why it is in my husband's house. This Kafia Bewa. Bewa means, that means in between, her husband died. It is nowadays it is reduced. Earlier, the widows used to write their names as Bewa. But actually nowadays it is vanishing. So the society is enlightening, and accordingly the thinking of people are also being changed. So these things are very much crucial that I have a good case. So far regarding, I approached the Honorable Supreme Court, that Lordship may kindly see Supreme Court's order, page 82. Page 82. My Lord, here, hired the learned counsel for the petitioner and perused the relevant material. Permission to file additional document is granted. Application for exemption from filing official registration is allowed. We find no merit in the present special leave petition. The special leave petition is accordingly dismissed. This is Momina Begum. So this order was passed by Honorable Supreme Court. Thereafter, we have filed the review petition. Now, here one thing is said that we find no merit in the present special leave petition. No merit. The word merit is there, or somewhere it is at limine. Now, what is the meaning of merit? That has been discussed at length in a case of, that is, Lordship may kindly see, 2006 SCC 359, para 45. Para 45, I am reading, my Lord. Having thus made the law clear, the case at hand possesses no problem or solution. The earlier order of the High Court was sought to be subjected to exercise of appellate jurisdiction of the Supreme Court by the state of Kerala, wherein it did not succeed. The prayer contained in the petition seeking leave to appeal to this court was found devoid of any merits and hence dismissed. The order is a non-speaking and unreasoned order. All that can be spelled out is that the court was not convinced of the need for exercising its appellate jurisdiction. The order of High Court, that is so-and-so, did not merge in the order that is so-and-so passed by this court. So, it is available to be reviewed by the High Court. Moreover, such a right of review is now statutorily conferred on the High Court by subsection 2 of section 8C of Kerala Act. The legislature has taken care to confer the jurisdiction to review on the High Court as to such appellate orders, also against which, though an appeal was carried to the Supreme Court, the same was not admitted by it. An appeal would be said to have admitted by the Supreme Court if leave to appeal was granted. The constitutional validity of subsection 2 of section 8C has not been challenged. Though the Sri so-and-so, the learned senior counsel for the appellant, made a feeble attempt to raising such a plea at the time of hearing, but unsuccessfully, as such, please has not so far been raised before the High Court, also not in petition filed before this court. No fault can be found. So here, the no speaking order, non-speaking order. So when there is non-speaking order, that cannot be said that it bars the jurisdiction of review, or even the writ petition in Abdul Qadir's case, just few times back I have said. So review or writ is maintainable. So far, the same thing has been also expressed in the 2019 for SCC 376 para 28. Here, in para 28, Lordship would see, in the instant case, since a special petition was dismissed in limine, without giving any reasons, the review petition filed by the appellant in the High Court would be maintainable and should have been decided on merits. Or order dated so and so in Carol 824 passed by the High Court is accordingly set aside, and matter is remanded back to the High Court for deciding the review petition on merits. The civil appeal is disposed of accordingly. So both these two cases amply and clearly demonstrate that when the order is passed without making any reasonable observation, or what is the foundation of the orders, if that is not there, that is not on merit. Because Supreme Court normally in main cases summarily reject the petition. And that is why it is said that when such types of order is passed by the Honorable Supreme Court, it is open for the High Court either to accept a writ petition or in review jurisdiction to exercise its power. Because the High Court is a court of record. Today, what order would be passed 100 after 100 years, this should be interpreted, this should be researched, that what order was passed in one situation. So, in other words, during the first constitutional court, it is also the duty of the Honorable High Court to see that no injustice is done in the name of so-called formality or any laches on the part of the party, because citizenship is the most valuable right. So my submission is this, my lord. First submission I have already submitted in the case of joyfulness. In addition to this, today I have submitted some more points, and my respectful submission would be that the review petition should be allowed, or at least maybe remanded, because I have a good case on merit. I have so many documents. Due to fault of person, he should not be declared as foreigner. That is also said by our High Court in several judgments also. Only one thing I am submitting at this critical juncture, that Lordship would see that it is 2004 12 SCC 360. Here, any objection regarding a document must be at the trial stage, not thereafter. My learned friend says many, my lord, 2004 12 SCC 360 para 11 and 12. Here, any objection regarding a document must be at trial stage, not thereafter. Now my learned friend would say many things. But when it was exhibited before the learned tribunal, he or his representative kept mum. So the Honorable Supreme Court says, no, this is not the law. The law is this, that you should raise the objection at the earlier stage so that the person gets a chance to explain the position why he did not say this or why he did say this. So my submission all is this, my lord would kindly consider all these aspects and give this lady, I think she is very highly also, she is aged lady, and I think it's as her age would be 51 years in 16. So 51 plus 8, that is 59 years at present. So in this old days, it is not possible, and this my submission is that she should be either declared as Indian citizen, reviewing the order of the Honorable High Court and also setting aside the order of the tribunal, and or in the interest of justice, case may be sent back for retrial. That is my submission. So, এখনটা কইতে হবে ল তো দরকার নেই আপনার পরে হোক আমি ল দিও না আরো
May I please, madam? My lord, first of all, my submission will be, my lord, the review petition is not maintainable at this stage because it is filed after long after, my lord, 4 years. The order was passed on 6/6/2018. This review petition is filed, my lord, after almost 4 years on, my lord, 2nd of June 2022. That is very important fact, my lord, the important issue, because the original opinion was passed on 16/2016, upholding, my lord, declaring the petitioners to be foreigner. Then, my lord, WPC was dismissed on 6/6/2018, upholding the opinion. And thereafter, they approached before the Honorable Apex Court by filing an SLP, and which was dismissed on 29/2018. After 29/2018, though it was dismissed on withdrawal, my lord, they have approached the Honorable Court on 2nd of June 2022. And the most important part is, my lord, even though they have come after almost 4 years, the review petitioner has not given a single explanation. I'm not saying, my lord, of filing any limitation petition, but the review petitioner has not given a simple explanation as to why the petitioner did not file the review petition on time. I'm not saying, my lord, I'm not asking for filing of limitation petition. What is the explanation? There is not a single explanation to the effect. And this so my first submission will be, my lord, before going to the merit, the review petition may be dismissed on this ground itself. To place that, my lord, I have some judgment of this Honorable Court as well as Honorable Apex Court. My lord, this Honorable Court has clearly settled, my lord, this is 2011, my lord, 2 GLR 510. This 2011 2 GLR 510. There, my lord, 510. Modi Riba and others versus Yamkar Riba and others. There, my lord, para 4, it is discussed. My lord, para 4 has been referred to Kanak Chandra Sharma case, my lord, as passed by this Honorable Court. Thus, I'm reading out that para, my lord. Yes, this is Ansari, Justice Ansari and PK, my lord, division bench judgment of this. Yes. While para 4, I'm reading, my lord, that is referring the Kanak Chandra Sharma's case, my lord. While considering the case of Sri Kanak Chandra Sharma, it is need to be noted that though the Limitation Act may not apply to proceeding under 226, the Limitation Act is a statute based on public policy, which reflects legislative intent to ensure that no lease is brought to court of law for adjudication beyond the period which the legislature may prescribe. Thus, various periods of limitation prescribed by the Limitation Act are nothing but measurable standards, which are required to be applied for determining if an application for review of an order passed under 226 is within reasonable period of time or not. So that has to be seen. Since Limitation Act, as indicated herein before, reflects the public policy as regards the period of limitation within which a shall be brought to a court of law, the High Court too, while exercising its writ jurisdiction under 226, would normally not deviate from such public policy. So even though, my lord, the Limitation Act may not be accepted, is strictly followed, but the public policy, the policy has to be brought into. Policy has to be brought into in the writ jurisdiction. Then, my lord, your lordship may kindly see that discussing all these things, my lord. Then discuss para 7. It is discussed the Bhailal Bhai case, my lord. Para 7, it is said, in face of the decision of Bhailal Bhai, there can be no escape from the conclusion that the High Court jurisdiction is not barred in considering an application for review of an order passed by H under Article 226, even if the application seeking review of the order is made beyond the prescribed period of 30 days from the date of making of the order. When the High Court entertains an application for review, even after expiry of period of 30 days, the High Court, as a measure of public policy, must be satisfied that there were reasons preventing the applicant from making an application for review for reason beyond his control. Okay, they may apply after even after 30 days, but they must give reasons, my lord, which should show that they could not approach this honorable court due to reasons beyond his control. But in the instant case, there is not a single whisper, my lord, for why they did not approach in time. Similarly, in para 9, my lord, it is emphasized again. Para 9 again, my lord. It's in the review, especially in review. Because of what has been discussed and pointed out above, while we agree with the observation made in Sri Kanak Chandra Sharma Supra that the Article 124 of the Limitation Act would not apply to an application for review of order passed under Article 226 of the Constitution of India, we clarified that the High Court would not ordinarily entertain an application for review if the same is made beyond period of 30 days. Even though 124 is not applicable, my lord, then 30 days, beyond 30 days, it may not be allowed. As prescribed by the Limitation Act, on the ground that the public policy is not to ordinarily entertain in an application for review beyond the period of 30 days from the date of making of the order. It would, however, remain open to the High Court to entertain in a given case, an application for review, even if such an application is filed beyond the period of 30 days, provided that the High Court is satisfied that the applicant has sufficient reason for not being able to apply the review earlier. But I'm not saying they may not come. They may come, but reasons should be given which must be satisfactory to this honorable court. But they have not given a single reason. How can this review petition continue? So my first submission is that here on this ground itself, the review petition is to be. No. My lord. Yes. The judgment apex court. Yes. This is dismissed matter, like
It's only the record of proceedings, mind that.
yes. There may have my lord details, but
Certified copy of the order will reflect something.
yes.
Our court masters are keeping record in that register. They also write. Hard, dismissed, 2 lines, 3 lines, they will write. Now here, the court master and the assistant register. This is not the certified copy. The certified copy will have the signature of the honorable judges who passed that order. And I am sure this is, if we take out the certified copy, something else will come. There cannot be. Unless the certified copy.
On the left side of the copy, my lord. Yes, left side of the copy, my lord.
Have seen that.
Yes. And the small
That we have seen. Validity.
validity unknown, my lord.
See, who are there in the bench?
Yes.
Yes. And number one will never commit this mistake. Never. The Honorable Apex Court cannot commit mistake. But I am dead sure. The main order, that is why certified copy is not before us. Certified copy will come give you the reason. Normally what happens if you get it a copy, even in the website, you'll see the, because it is a proceeding, record of the proceeding.
Yes,
It's not the order.
record of proceeding. Right. Okay.
We'll try to inquire.
Yes,
In the website, you may see disorder on,
yes,
but
my
the
lord.
file will disclose something else. Okay, you can proceed.
So, my lord, my first ground was that due to delay, it may be dismissed at this.
There has to be some explanation.
There has to be some explanation. There is not
Second-
a single explanation in that case. Secondly, I like to rely on the judgment of the Honorable Apex Court, my lord, delay in lapses. That is, my lord, civil appeal number 5027 of 2024.
Oh, that day you gave,
Yes, Minmoy Mighty, my lord.
Minman Mehti. Oh,
Yes, that's
fine.
I relied on that day, my lord. That day, that is para 11 onwards, my lord. Para 11, 12. Then, my lord, another issue, my lord, which Honorable Apex Court had depreciated that this practice should be stopped, my lord. My lord, and the present case, my lord, and the judgment, which is under silence in the review jurisdiction, my lord, that was passed by Honorable Justice Ujjwal Bhuya and Justice Rumi Kumari Phukan sitting together. And this case is filed after transfer of Honorable Justice Ujjwal Bhuya and just before the retirement of Justice Rumi Kumari Phukan. Just before the
That
retirement.
day also you have cited one
Yes, yes,
justice, present CJI's order.
yes, my lord.
and
That
small
is,
judgment that we have.
yes,
placed.
my lord. That is 20,
Hunting,
yes, 2021,
hunting
my lord.
bench.
2021 7 SCC 206. 2021 7 SCC
That's right,
206.
that's right. We have noted down. To look for hunting of benches, they will get in judgment from our High Court also.
Yes, my lord. That adjustment. But because the order was
Their
passed in
lordships have
2018.
explained that
Yes,
after how many days of retirement of
Yes.
the previous,
yes.
they could have filed it early, but they have not done it.
That,
So that itself the
my
ground.
lord, instant case will show 2018 to 2022, my lord, 4 years old. So this case is applicable for that, my lord. Herein it is said, my lord. May I read that portion, my lord?
It's okay, we are aware because they could
Yes,
yesterday
yes.
only made submission.
My lord, para 2 and 3, my lord.
Hmm.
Para 2 and 3. These are that wrong. Now, my lord. So my submission will be, my lord, on these two grounds, it's also itself the review petition is not maintainable now, and it may be dismissed on that ground itself. Now, on merit, my lord, if we see what are the grounds of review, my lord? My lord, the CPC has said clearly said when the review can be filed. Just I'm reading out two, 3 lines of the CPC, and my lord, order 47, rule 1, my lord. Any application considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. First of all, against whom no appeal is preferred, by a decree or order from which no appeal is allowed, or by a decision on a reference from a court of small causes, and who, from the discovery of new and important matter or evidence, who is after exercise of due diligence, my lord, this has to be considered, my lord, which after exercise of due diligence was not within the knowledge or could not be produced by him at the time when the decree was passed or order was made. Your lordship may post this here for a moment, my lord. My learned senior friend is arguing that he had a sister, she had a sister, she has been declared Indian, so she may be given the benefit. She is having a sister that was under her knowledge. The sister had a case pending in some tribunal that was under her knowledge. I don't know when did my lord order the sisters have been declared Indian, because the judgment, the opinion is not annexed here, nor it is stated in the my lord review when the sister has been declared Indian. But these were under the knowledge of the my lord petitioner, and they did not disclose, this petitioner did not disclose all these things either in the written statement or in the evidence. In neither place she has disclosed that she has a sister and against whom there is a case pending, or she has been declared for Indian. There is no whisper at all. Now, after concealing that fact, now to get benefit, she is saying I may be given a benefit of that order and the order may be reviewed. It is not the court of fact. And the fact has to be decided by the tribunal, and the tribunal, they were silent. What is the due diligence? My lord, the Rule 47 says, clearly says, my lord, if new facts, important matter or evidence, which after the exercise of due diligence, what is the due diligence? In fact, my lord, our High Court rule has says, my lord, Rules chapter 10(3), my lord, it has said if there is any new evidence that could not be produced even after due diligence, that has to be given, my lord, brought by a separate, my lord, affidavit saying that even after due diligence, these facts or these evidences could not be produced at the time of trial. That is not done. That is, my lord, our High Court rule has said, my lord, chapter 10(3), my lord. After the exercise of due diligence was not within the knowledge, it was within the knowledge of the proceeding. If the sister, the my lord, person who has been declared is an Indian, is really her sister. That is the point, my lord. If the person declared is really her sister, it was definitely under her knowledge. But that was not disclosed or could not be produced by him at the time when the decree was passed or order made. And when the decree was passed or order made, decree was passed, the order was made in 2016 itself. Yes, 2016. Opinion was passed in 2016 itself. These things were not brought into the knowledge of the tribunal. Now they are claiming that, my lord. It cannot be, my lord. And secondly, my lord, where is the error apparent pointed out by the petitioner in the judgment of the tribunal, the Honorable High Court? But we are not coming here against the, my lord, tribunal's order. We are not coming to hear the, my lord, entire writ petition. We are not coming to, we are here to, my lord, hear the entire, my lord, the facts of the case. We are here to find out if there is any error apparent in the face of the record. And what is fact, my lord, error apparent? That is, my lord, that has been given, my lord, defined by the Honorable Apex Court in numbers of cases, my lord. What is error apparent? My lord, this is 2014 SCC, my lord, page 77. 2014 SCC, page 77, my lord.
Fourteen SCC.
14 SCC 77. State of Rajasthan and others versus Surendra Mohnot and others. There, my lord, para 23, 24, 25. This is relied on the judgment of the Honorable Apex Court, earlier judgment of the Honorable Apex Court, my lord. Para 23 says, in Tungafandra Industry Limited versus State of AP, while dealing with the concept of review, the court opined us. This is year 1964, 13 SC 1370 was referred. There in para 11 it is said. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard or corrected, but lies only for patent error. We do not consider that furnishes of suitable occasion for dealing with the difference exhaustively or in any great deal, but it would sufficient for us to say that where without any elaborate argument, one can point out to the error and say, here is the substantial point of law, which steers entertained about it, clear case of error apparent on the face of the record. So what is face of the error apparent on the face of the record? The error should be without any elaborate argument on, and one could point out the error. There must, and say, here is a substantial point of law, which stares one in the face. Secondly, para 24, my lord, para 24, it is again explained. In Northern India, Caterers Limited versus Lieutenant Governor of Delhi, Justice so-and-so, while speaking about the jurisdiction of review, observed that it is beyond dispute that a review proceeding cannot be equated with the original hearing of the case, and the finality of the judgment delivered by the court will not be reconsidered, except, my lord, this is where a glaring omission or patent mistake or like grave error has crept in earlier by judicial fallibility. So that has to be there, my lord. Where is the glaring omission by this honorable court in the earlier order? Where is the patent mistake committed by this honorable court? Where is the grave error that has not been pointed out by the petition? Secondly, para 25 again says, my lord, an error which has to be established by a long-drawn process of reasoning or points where there may conceivably be two opinions can hardly be said to be an error apparent on the face of the record. So it cannot be said. My lord, their first ground is that the sister have been declared Indian, so she should be given the opportunity of, my lord, she should also be declared Indian, and so review jurisdiction may be, my lord, imposed on. But as I have submitted, your lordship will find in the WS at page 52 and the evidence at page 63. Your lordship may, if your lordship may kindly go through. There is not a single whisper that she has any sister in the name of, in any name, or she has any siblings, and there is any case pending against her siblings. Same is in the evidence, my lord, evidence at page 63. Page 63, there is no, my lord, statement at all. So now, in fact, my submission will be, my lord, it's the fact which were mal concealed by the petitioner at the time of trial. And another ground they have sought, my lord, that the voter list of 66, 89, 85, and the link certificate of the secretary was not considered. That is very well considered by this honorable court in the military jurisdiction. Your lordship will find, my lord, that judgment at page 19, my lord, para 11.1 onwards, the details discussion of all these documents are here. So all these were considered and their prayers were negated. Now they cannot come. My lord, I have, last occasion I have relied on that, my lord, Kamalesh Burma judgment, that is probably there, 2013 HCC 320. This clearly said, my lord, the Honorable Apex Court, that once the argument which is negated by the earlier, my lord, bench cannot be, my lord, a ground for, my lord, the review, cannot be ground for review in the review jurisdiction. So all these grounds, all these, my lord, arguments were made there in the read court. Those were negated by this honorable court after giving considerable, my lord, consideration. So the ground number 1 is not maintainable. Ground number 2, my lord, the NRC details, and ground number NRC details, my lord, I would like to come. In fact, this is if Momina Begum's name is appearing in the NRC, which is not yet, my lord, finally published, but in the, my lord, draft list, then it is error committed by the, my lord, NRC authority, because the Honorable Apex, this Honorable Court has, in number of occasions, a number of cases, it is said, once a person's name is if a person is declared foreigner, his name cannot enter in the NRC process. So she has misled the NRC authority and entered her name somehow by misleading some documents, either by fax. So this cannot be a ground which is illegally done. That is an illegal act, man. In fact, if she has misled the NRC authority, there should be some proceeding against her. But I'm not saying that, my lord. But that illegal act cannot give her a new right for review, filing a review before petitioner. And secondly, the NRC is not yet finalized. The NRC documents are not, my lord, not admissible as of now, because these are not finalized, not published by the authority with due process. And the next, my lord, and these are the grounds, my lord, taken by them.
Mr. Payang,
Well,
Mr. Mahmood has himself pointed out few things. That page number 84.
80, my lord.
84.
Yes.
You have said that name of Momina Begum, the petitioner,
Yes.
has been accepted in the draft NRC, right?
Yes.
Look at the village.
Village is Jogi Guppa.
No, above that. Village is Jogi Gopa.
Yes, ma'am. Village name and Koibotro, Kobaitari, part
Part 5,
5.
471,
Yes. LRCR address, DP office.
right?
Yes.
This is very important to note. Then later on, she is claiming that is 86. This Monirul Haq is her brother. That relates to village at the top, you just see. Proprietary part 5. The village is numbered, mind that. This is important. Then another brother is 88. That relates to village. Proprietary part 4. These are all draft, we are not saying anything.
Yes.
Then next is page number 90. That relates to her son. Proprietary part 5. Now, the petitioner tried to link with as you have seen, which you have pointed out, Come to page number 58. Or before that. Come to straight away 58, para 5.
Yes. Modern
Let me read for all of you.
That the name of the
That
father.
the name of the father of opposite party is late
Kapoor Singh.
Kapoor Sheikh. And name of the mother of opposite party is late Tohar Banu. And their names have been recorded in the voter list of 1966 under 43 number Bongaigaon LAC district and subdivision Goalpara police station North Salmara of village now just see this is 205 Kovaitari part 4 white serial number 3 and 4 respectively and house number 2. This is 205 Kovaitari part 4. I am from a village, I know. There will be same name of a part of the village, like circles are there because non-cadastral map will be there for certain land. The big area will be named. Let us assume it is a Kobaitari. It will be part by part. Part 3, part 4, 5, 5. If you see any such land map of in the revenue department, you will see. Then the villages are numbered. The same name, the village will have different number.
Yes.
This is 205 Kobaitari part. Now, if you match this, is 88, 89, whatever you see. These are
470, 471.
one is part 5, one is part 4. Is not 205 has been marked Kobaitari part. Now, petitioner claims her father is Kapoor Sheikh, mother is Sahara Banu. Sahara Banu. He is shown that affidavit in 2015. Now, please come to page number 81 or in fact 80. In 2016 April,
Yes.
petitioner is relying on this.
Yes.
Gaon Panchayat has given a
Certificate.
certificate.
Mother is alive.
Mother is alive.
But in WS was filed.
Leaving aside anything, see the petitioner's case, how she wants to play before the,
Yes.
how trustworthy it is before the. And we feel how the court is cheated. And I feel sad. We are here to do justice. We don't fraud any people. And what do you feel when you go through everything like it?
WS was filed on 7/10/2015.
That-
Their street
It
mother
is
is
your
late.
duty to point out. It is not the court's duty to scrutinize everything. Was there any reason for the petitioner to do this before the court? We can be very harsh, but we do not want. Secondly, her case is fully coercive. Now, if you see, what you will see it's Kafur Rahman and Kafur Ali. There is no mention that Kafur Rahman, Kafur Ali, Kafur Sheikh is the same person.
Yeah.
Villages are different. Now, we are not saying anything against the particular finding of the tribunal. With regard to one Kafina Begum. It is at page,
90.
this is page 95, you just see. FT cases of 2011.
Yes.
Come to page number 98. The certified copy was obtained in 19th of March 2019. So review could have been filed immediately.
Yes.
In receipt of this certificate. Then come to the page 96. I don't know what the Home Department is doing. Look at the exhibits. A, B, Kapoor said, which the petitioner also relied, exhibit A. Here there is no mention about the numbers of the village. We have seen the petitioner has pointed out, has annexed a voter list of 1966, which is very clear that it relates to 205 Proprietary Part 4. The petitioner has also mentioned in her written statement. In these exhibits, there is no mention about that.
Yes.
Then later on, you'll come exhibit. The next page.
Okay.
That relates to Proprietary Part 5.
And that is wife is Kapoor Ali. Wife of Kapoor Ali, not Kapoor.
Is there daughter of late
Yes.
Kafur Rahman? Who is Kafur Rahman? Then, as you have seen at page number 86, Monirul Haq,
Yes.
younger brother of the OP, which the petitioner is now claiming. He is from
Part 4, Proprietary Part 4, 47.
clearly mentioned Kafur Rahman. Then come to the points and reasons to the decision. Fourth paragraph. Kafur Rahman.
Hmm. Jamabandi says, my lord, record in the Jamabandi is continued.
Kapur Rahman
Yes.
of which village? Kochamari part 5. Anyway, any other points you like to place?
No, those are the points, my lord. Only my lord, last submission is, my lord, this, the grounds are not meant.
Yes, Mr. Pai.
My lord, the, as the lordship has already pointed out, my lord, I have also seen. My lord, the, my submission is that, first of all, that, my lord, order of the, my lord, sister, projected sister, cannot be a ground for, my lord, review in this case.
No, that's why he is
Yes.
special Abdul
Yes.
Quddus para 28.
Abdul Quddus para 20 had not provided any right to them, my lord. As I have last occasion argued, my lord. Para 20 says,
So it's the ground of review.
yes. No. My lord, that is, for that, my lord, as I will submit, my lord. First of all, they has to prove, they has to link themselves. One person, if say, I'm the brother of A, my lord, that will not do. If the petitioner in the, my lord, proceeding in the tribunal had a plea that I had a sister in the name of so and so, and she has against her there is a case pending, and that is not yet decided. If that is decided, my lord, in her favor, then she could have get the benefit. But now, suppose this Kafia Begum, if someone Afia Begum is also declared Indian, she may come. Yes, that is my sister, even though there was not a single whisper about her sister. Then, my lord, each and every case has to be reviewed. That is not the case, my lord. The case court has said, my lord, the court, for that to get that benefit, first of all, my lord, the petitioner or the proceeding has to prove that I am the brother or sister or daughter of that person. That is the point. Has to be this, my lord. There need to be, my lord, proof in the tribunal. Once, if he could prove, my lord, that Kafia Begum was her sister, and against her there is a case pending, if that is, my lord, decided in favor of Kafia government, then, my lord, the para 28 of the Abdul Quddus had come. Because she has not pleaded anywhere that she had any sister in the name of Kafia Begum. So she may come today, and tomorrow, if she failed in this case, tomorrow she may come that this is my sister or this is my brother, she is Indian. So I may be given the opportunity of mother to rehearing.
Do you have Abdul Quddus judgment with you?
Yes. First.
You have.
Yes.
Read para 28 very, very slowly. But remember, this is a case, background of the case is NRC.
Different. But sorry,
This is a case of NRC where it has been considered.
judgment is there, but the last page is not. There are- Certainly, my lord. Last page पे गए थे।
If you read the entire judgment, you will know in
Yes.
what circumstances this para 25(8) has been considered.
Para 28, my lord.
Para 28. Read very slowly.
Yes. Para 28. It was
Because
highlighted.
it has relevance of the previous paragraph.
Yes, ma'am.
So, in fact,
Para 27 onwards, may I read it? Then
no,
earlier-
not required because the background is there. It is
Yes.
coming there and solicitor, and thereafter this is the process.
Yes, my lord.
Because having those previous paragraphs,
Yes,
then the Honorable Apex Court has said so.
Yes,
Just read it.
it was highlighted that there could be contradicting decisions, opinions of the foreigners tribunal, even in cases of near family members, albeit contradictions can be avoided when family tree hearings are held, as is now being undertaken.
So, family
Tree
three hearings were undertaken during the NRC.
NRC process.
So, in the latter process where there is a family in the foreigners tribunal, when it was, there may be contradicting
Yes,
decisions. and
there may
opinions,
be contradicting this.
right?
Yes,
Because it is not hard to gather the family member.
yes, ma'am.
Then
In the absence of joint decisions, conflict is possible as the principle of res judicata would not apply to separate proceeding even if against two closely related but different persons, as each case has to be strictly decided on the facts and evidence on record.
please hold on.
Yes,
So, this particular paragraph clarifies that each of the case
Yes.
have to be decided on the
On the
basis
fact-
of
facts and evidence on record.
facts and evidence on
On
record.
record.
Then proceed.
Secondly, there is a possibility that one of the near family members
or one
or
of his
one,
near family.
some or one of the family members may have migrated to India prior to midnight of 25/3/1971. It should be 71, not 71. And therefore, fell in different terms,
different category.
fell in different category. Any such conflict, my lord, here your lordship will
Yes,
have.
yes, please.
Secondly, there is a possibility that some or one of the family members may have
Come prior
migrated to India
24th of
prior to
March,
midnight of 24/3/1971.
1971.
So, if she has come prior to 71, she will be declared Indian.
That's why the
Otherwise-
situations
yes,
may vary.
situation may
That
vary.
is what the apex court has said.
Therefore, fell in different category. Any such conflict, however, would not compel us to take different view in terms of the clear statutory provisions.
That means what?
My lord,
Means, so the other person has come before, he is now Indian, so I am
Yes.
also his brother or sister, so I
That-
may be considered to be an
yes,
Indian.
that will be not.
The court said no.
In a given case,
Hmm.
in a given case, my lord, the person aggrieved would have liberty to invoke writ jurisdiction. They may invoke writ jurisdiction, or if necessary, review jurisdiction before the High Court or this court to ensure that no injustice is done. In a given case, they can approach, but my lord, prior to that, the records, my lord, evidence on records and facts has to be seen.
Did it then comply? Then
Yes.
next part, any other,
Yes.
any order?
Any order passed in case of close family members subsequent to adjudication order determining the citizenship status of person would necessarily be a material evidence which can be duly taken note of and considered while deciding a writ petition or review application.
Now, you have to tell us one thing. Whether this will be with regard to NRC or with regard to the matters decided by the foreigner.
My lord, the issue here is, my lord, the
Purely
issue,
NRC.
yes, purely NRC, as I have submitted, my lord.
Now, sister has pointed out one thing. Please come to come to page 20. Para 10.
Yes. Para 10, my lord. Petitioner was also subject to cross-examination. She stated that she had 3 brothers and 4 sisters. The brothers being Manirul Haq, Zahirul Haq, and Mahibul Haq. Zahirul Haq had expired, but other 2 were alive. She also stated that she had 4 sisters, namely Rina Begum, Kafia Begum, Rafia Begum, and Rafitun Begum. Petitioner admitted that in 1997 she was marked as doubtful voter, and from them onwards she could not cast her vote.
The tribunal,
Yes,
during her
cross-examination.
because the record was called for by the coordinate bench while deciding the matter.
Yes.
You will go to para 3, you will get it. Now, you just see
This court by order that have issued notice to requiring the case record and passed an interim order to the effect that the petitioner should be allowed to remain on bail.
come to 12.4 or 12.1 onwards.
Firstly, the another state certificate, that is the secretary certificate, secretary of Koibatari Gaon Panchayat.
Proprietary.
Yes, Koibatari Gaon Panchayat not reposed before this tribunal along with the contemporaneous record to prove activity as well as the contents thereof. Therefore, the document was not proved. Secondly, in Rupjan Begum versus Union of India, the Supreme Court has indicated that such a document by itself would not be proof of citizenship unless it is thoroughly verified. It has to be verified at 2 stages. At the first stage, the genuineness of the document itself would have to be verified, and the second stage, the genuineness of the contents would have to be verified. There is nothing on record to even remotely suggest that the state certificate was subjected to such verification. Lastly, we notice that the state emblem of India is embossed at the top of the certificate with the motto Satyameva Jayate, printed at crescent format below the lion capital. Rule 10.2 of the schedule of the state emblem of India regulation of use rule 2007, framed under the state emblem of India prohibition use act 2005, specifically prohibits Panchayati Raj institutions such as Gram Panchayat from using the state emblem of India in any manner whatsoever. Therefore, embossing of the state emblem of India in Exhibit B certificate is in violation of the prohibitory mandate of Rule 10.2 is clearly unauthorized. Thus, unauthorized use of the state emblem of India has rendered the certificate inadmissible in evidence that a part, as per the design prescribed in the Appendix 1, Appendix 2 of the aforesaid text, has to be written below the profile of the lion capital of Devanagari script in a straight line. Therefore, writing of motto Satyam is in consent format, recent format, deviating from the certificate format is clear take away this document not to be certain. 12.4 states is if Exhibit B is excluded, my lord, B is the Panchayat certificate. From consideration, there is nothing on record to establish linkage of the petitioner with Kapoor Singh, whom she claimed to be her father and a citizen of India, relatable to period of prior to 25/03/1971, which is the cutoff date of identification of foreigner in the state of Assam as per 6 of the Constitution of Amendment. So, my lord, the petitioner.
Now, please come to page number 58. That's a written statement.
Yes.
Because 1, 2, 3 doesn't say anything much. You read by yourself as page 57 to 60. We did not find anything that she stated that she had any siblings.
No, my lord, I have already pointed out he has not stated anything, man.
Now, come to her evidence in affidavit.
Yes. Page 63.
63 on.
Yes. There also there is no discussion.
Then please come to page number 28. Now find out in the repeated that's it. We have not found anything.
Yeah. That is it. What I would say.
Remember, this writ petition was filed on 6th of May 2016.
Yes.
We have the records before us. Read para 30.
30 much. The petitioner has also, in the meanwhile, obtained a certificate from the Secretary February Gram Panchayat to show that names of the legal heirs of the late Kapoor Sheikh, which include the petitioner.
Even when she did not state,
Yes.
but at the same time, read para just edit and
Interestingly, in para 26 said, my lord, the petitioner had named one of the sister as a witness,
no, about this he mentioned.
but name is not mentioned. Who is that sister? That's what I wanted to point out, that name is not mentioned, even though it is.
No, in the same petition, petitioner stated that had our parents been alive, she could have proved it. Is there some? Just read which particular para? Could not just mention.
My lord, para 19, my
Para
19, 19.
19. You had mentioned some.
That the petitioner is illiterate and was born in home, that too in the year 1964. And as such, there is no other certificate available with the petitioner to show her linkage with the parent. Moreover, the parents having expired, she could not have produced them as witness.
But that Annex 12.
Yes.
Clearly reveals something else has been pointed out right here. Anything you'd like to add?
My lord, my submission is that this is a review petition filed against the judgment and order of the Honorable Court. So they have to point out that what is error apparent in that. They are, my lord, arguing here and there, saying that the tribunal has committed this error, error. They have they have the opportunity of appeal, going to for appeal before the Honorable Apex Court. Let them go. But review jurisdiction is not for that, my lord. As I have pointed out, my lord.
No, he said that because of para 28, it has been filed a review petition.
No, my lord, what is that? The para 28, first of all, my lord, I have argued and again, I have said that, my lord, the para 20 is not giving them every right. It is in given case where the facts and evidence in record says, yes, then on.
Okay. But
First of all, my lord, the delay is not explained. So for that reason itself, the review. My lord, I'd like to point out that, my lord, the judgment your lordship has probably did note down. 2013 HSCC.
what Mr. Mahmood has also pointed out, that regarding the judgment of the Apex Court, 2006 SCC 359, married.
Yes.
Now, in
No,
the
this
order
is
which has been
not on
passed,
merit, my lord. This is not passed on merit.
this, the order passed by the Honorable Apex Court did not state the reasons for which the petition was dismissed. So documents have been considered. So considering that as of the matter, Mr. Mahmood submitted, the petitioner has a right
To file a review.
to prepare a petition.
My lord,
So his argument is that since there is a subsequent development, sister has been considered to be an Indian citizen.
I'm-
And their names and the final draft.
Yes.
So
that's the argument. My lord, I'm not saying that they may not argue that. The grounds, if it is substance, if your lordship find it that there is a force in that argument, or there is a, my lord, there is a point on that, your lordship may accept it. I'm not on that. But my lord, why delay? At least there should be explanation. My point is that why there is no explanation at all. My lord, without explanation, how can we accept that, my lord, the delay? Where is the explanation? There is not a single line of to explain.
Okay.
And secondly, my lord, merit. It is not, my lord, it is the petitioner who had seek for withdrawal. Petitioner seek for withdrawal. They
Very
prayed
good.
for withdrawal.
read the order, read the order,
Yes,
page 82, I believe.
please it. Heard the learned counsel for the petition and peruse the relevant materials. Permission file additional affidavit document is granted. Application for exemption from filing official is translated is allowed. We find, oh, sorry, ma'am. We find no merit in the present special leave petition. The special leave petition is accordingly dismissed. Yes, this is dismissed. I thought, my lord, it was written. This is dismissed on merit. That's why your lordship may, if they may have something more in the order, my lord, judgment and order. Permission for file additional document is granted. Application for exemption for filing of official translation is allowed. We find no merit in the present special petition. So there must be some more order.
Yes, Mr. Mahmood, anything you like to add?
Hello. If you right to answer, first thing, my lord, the review powers 2005 for SCC 741, para 88, 89 and 90.
That you have given, I believe.
I have given it,
Hmm.
but I did not explain it. Because my learned friend has said, so what does the order, para 89 only I am reading.
Hmm.
Order 47, rule 1 of code provides for filling an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of the record, but also if the same is necessitated on the account of some mistakes or for any other sufficient reason. Now, subsequent development is a good cause of review petition. So, My learned friend has argued in a confusing manner. One time he says that no. One point he said that review would lie if something is discovered without elaborate argument. But learned friend has made elaborate argument. Elaborate argument is not necessary, because on the face of the record, it is evident that public documents have been not taken into consideration. 1966 voter list is there.
It was considered.
19 consider means what? Then that will be another argument. What is the meaning of consideration? Consideration should not be in the air. It should be on legal sense. Here, my learned friend said that no elaborate argument necessary, but he has made elaborate argument. Now, our submission is this: yes, no elaborate argument is necessary. I also support him. But here, 1966 documents are there. 70 documents are there. Those are not properly considered. That is my case. Now, so far, NRC, as per section 15 of the NRC Census Act 1951, my lord, NRC is not the proof of citizenship. But the NRC which is prepared this time, it has got legal value. It is a proof of citizenship. I have not brought today, but the Honorable Supreme Court in the Public Works, it is clearly said that for the purpose of citizenship, the following documents are necessary. What are those documents?
10 list of documents.
Yes. It is clearly stated that for the purpose of citizenship, the following documents are relevant. All the documents are not necessary. Any one of them is enough. Among them, NRC 51, it is said, if my learned friend denies it, tomorrow I may bring it. Details I have not met, but in this my small book I have written that NRC 1951 is one of those documents, extra copy of the voter list of before 24th March 1971. And there are other refugee certificate, etc. These are not applicable in this type of people. So here, the most important NRC 51 and voters list of before 24th March 71 are not taken into consideration, though those are public documents. And so far, this NRC of this time, it is legal for a citizenship because it has been done at the supervision and order of the Honorable Supreme Court. That is enough.
Okay.
Then, my lord, what my learned Honorable Court has pointed out, let me clarify a few points, my lord. Earlier, my lord, in Guwahati Municipal Corporation, there were, I think, many wards were there. Later on, it is reduced. Now, suppose this area was earlier in ward number 40. Now it is within ward number 15. So these are the process of governance. Now, Lordship, may kindly see for a moment, page 39. Here, my lords have raised a question, capitally part 4 or 5. These are immaterial because these are possible. Because before coming 10 years back, what was the ward number 20? Now it is 12. So does it mean that these persons have come newly from Bangladesh? That is not, because these are the procedure of the government's policy matters. So 5 or 4, these are not material fact. Thing is this, Kabaitari is there, part 4 or 5. Sometimes areas are redemarcated or demarcated. So areas of 4, 5, 6, etc. This Kabaitari. So another thing, Lordship, but my Lordship raised, I also want to clarify this position that my Lord may now kindly see page 81. Page 81. This is the Panchayat certificate. Here, Shoharbanu, wife, that means my mother, Rina Begum, Kofia Begum, that very lady who has been declared as Indian. Momina Begum, her name is with that sister, and address is Kabatari, part 4. So it is annexed in the writ petition. So it is not a new document. So this document bears the name of Kofia Begum and Momina Begum. And in the same village, Kabatari, part 4 or part 5. That is, of course, difference matter. So that is the one thing, very important thing, that I have not come or automatically just now that I have come not. That is not. It is, since earlier it is in the record. Now my lords have also pointed out one thing, page 58, para 5. That the name of father of opposite party is late Kapur Sheikh, and the name of mother of opposite party is late Shohar Banu, and their names have been recorded in the voter list of 1966 under 43 number Bongaigaon LSC, district and subdivision Gwalpara, PS North Salwara of village 205 Kabaitari, part 4 is there. Now here Lordship would say, it 43 number Bongaigaon LSC. Now this Kabaitari is within Obhavapuri North LSC. Perhaps this time has again changed. This time again has changed. Earlier this Kabaitari was at within Bongaigaon LSC. Thereafter, Obhavapuri North LSC. And now I think for recently, just recently, 6 months back, it is again redemarcated. Perhaps it has been fallen in some, that is Sijongam, I think Sijongam. So after 20 years, if my learned friend Mr. Payan comes and says, no, he is from Sijongam, not from Bongaigaon, then it will be very difficult on my part. He will do all these things and he will take the benefit. That is not the law. So, secondly, in page 6, para 6, the opposite party was born and brought up at village Kabaitari, part 4. Everywhere my case is that. So, my lord, what the points my learned friend said, another thing, my lord. My learned friend has said one thing, that is regarding this explanation regarding this delay. Here, my lord, delay, of course, it was better if the proper explanation should have been given. I understand that that is not given. That is my lectures. But what does the Honorable Supreme Court says? 2006 5 SCC. 2006 5 SCC. No, it is not told earlier because my land read this issue, so I am answering this. 2006 5 SCC 353 para 11 and 12. Limitation, my lord.
353.
353 para 11 and 12. Limitation ordinary bars of remedy but does not extinguish rights. So it is my right, citizenship right, fundamental right. it is said by all the jurists of the country that the most valuable part of the Constitution is part 3, that is fundamental rights. So this is, of course, I admit that it should have been explained, but I did not do that. For that, I do not want to take that it is not our fault. It is also our fault. But even then, it will not extinguish my right of citizenship. Similarly, my lord, 1999, 4 SCC 450, para 8, here, maintainability, delay laches, when delay fatal, delay by itself may not defeat the petitioner's claim for relief unless the position of the respondent has been irretrievably altered or he has been put to undue hardship. So,
1999 4 SCC.
99 4 SCC 450 para 8. Here, delay by itself may not defeat the petitioner's claim for relief. So, suppose, my lord, if your lordships allow my petition without explaining the delay properly or without filing a limitation petition, then what will be? What will be their harm? Suppose I have made an application that is allowed. So, if it is not allowed, so whether the state will suffer any loss, what they will get? They will get nothing. So, due to not explaining the reasons of delay, that may be a mistake. That may be a mistake, but not fatal. So, in this viewpoints, my lord, I hope that I have answered all his legal arguments and as well as the queries which were raised by this honorable court. So, my submission is this: everything for the ends of justice. To provide justice, sometimes this is also the law, that to provide justice, always court need not wait for a statute. Court has a another discretionary power. So in that view, my lord, I have a good case, at least for remand. That is the sir.
Only one point I would like to point out, my lord. The entire judgment of the my lord, earlier division bench of the Honorable Court my lord, have considered the 6171 old documents. My lord. There is no dispute. We are not disbelieving all those documents. Those are considered. Only point was in para 12.4, my lord. On what basis the person has been declared foreigner. That is the consent certificate. He did not prove that consent certificate. Where is the link? The my lord, review of
We are not on merit of the case.
yes, that's why I'm saying my lord, review. No,
Then I will answer. Again, I will answer.
The
You are
thing
not
is
on
that
that.
If we raise
no,
this issue, I will
I'm not
answer.
on. I want to point out only one point, my lord. Review is maintainable unless the material error manifests on the face of the order. Undermine it.
Kamlesh Verma is sufficient.
Yes,
You have maintained
Kamlesh
it.
Verma has pointed out.
Sufficient.
So it is sufficient, my lord.
But at the same time, we have also to read other aspects which Mr. Mahmood has cleared.
Yes, definitely, my lord. But
There is
only-
a
only
consent
point
certificate
is
only
that
a link document, not
suppose-
the citizenship proof.
suppose, my lord, suppose the sister has been declared for Indian, my lord. She has proved, because if we see, my lord, sister has been declared Indian on the basis of some other documents which were placed by her in the tribunal. Those documents were not placed by this petitioner. So this will not give any consequence, my lord.
Lord, what I produce is not believed. What I have not produced, they want this.
No,
That is the problem we are facing.
Mr.
we need only link document. If link is proof, there
Link
is
is
nothing.
66, what
Yeah.
better document?
Link is consent certificate. That is not proof.
In Bangladesh also, there are husbandship, board of people are also there. As far as village is there, board of village is there. I have seen in net. So, পায়ে তাতে কোথায় দিব লাগবো?
বাকি রয়েছে। Oh, yeah. This matter was called. None appear to
Here we go.
be on call.
No, no, তোমার here we go.
This matter was taken up for consideration even in the first half. Taken as second, 100. Reported that it is a- earlier. Still allowed. Well, okay. Perfect. Give you 15 equity. Okay. Less up to it.
শ্মশান ঘাটত গ'লে গম পাব শ্মশান ঘাটত গ'লে গম পাব এইবিলাক অন্যায় কৰি আছে ধৰিব না এই গরিব মানুহ কি অত্যাচাৰ কৰিছে